Get a grip and get a chip. Won't even trip. Though my cup was running over, I took only a sip. Stay hippin', then I'm hopping, I'm dropping. It won't be flopping, no shock. That whatever I'm selling, you will be copping. He was the strongest, though he was the one that cried. And he chose to kill his brother because he was from that side. And why? He chose this son because this one had pride. And instead of the narrow road, he chose the one that's wide. Sometimes the one that won was the one that tried. And the one who pulled the gun was the one that died. Looking good, a good look is the one that's fine. If I had to pick, fly would be the one that's mine. G-O-D, in the place to be. Attendee, Hard Knocks University. And since kindergarten, they've been hiding the knowledge. Homeboy is self-taught, never went to college. I'm brown skinned, I'm from Pelon. Rainy alarm, but I remain cool and calm. Reading Psalm, fire like napalm bomb. It's the content creator with force like Darth Vader. Back on the track with the facts and all that. One path is the way that I'm taking, getting closer to God in the tight situation. Tonight we're going over the Annotated Glossary of Terms from Cracking the Code 3rd edition. This is a word game going on in this day and age. People, make no mistake about it. And without further ado, this lesson will begin now. Annotated Glossary of Terms, Cracking the Code. Note UCC means Uniform Commercial Code per UCC subsection 1104. When there arises a conflict between current code and a deleted section, the deleted section controls. In other words, nothing is ever actually deleted. Therefore, earlier editions of the UCC would be useful. Introduction. Do not expect to understand the UCC at a glance. It is a culmination of thousands of years of effort by countless collaborators and was never supposed to have been deciphered. Understanding the code can be likened to solving a giant jigsaw puzzle. One is not going to see the picture with all the pieces in disarray. A few pieces must be connected before one can gain awareness of the fundamental issues at hand, build on them, and eventually solve the puzzle. But this need not take an inordinate amount of time. One good way to go about it is to follow the annotations accompanying the definitions of terms that direct you to see and compare other related terms in the glossary. By gathering bits of understanding from different places and from different points of view, the pieces of the puzzle begin to fit together, and the big picture can take shape very quickly. There are a number of key terms that will provide a good entrance point to the glossary for gaining an understanding of the redemption process. Some of those terms would be straw man, birth certificate, transmitter utility, value, redemption, and House Joint Resolution 192 of June 5th, 1933. An entertaining and all-inclusive definition is found at Wizard of Oz. Do not be daunted by the size of this glossary. All terms have bearing on what has happened and is currently happening. Therefore, making it very interesting material for anyone concerned about survival and freedom. Key. So when you see ACED, that means American College Encyclopedic Dictionary in 1959. You see AHD is American Heritage Dictionary, 1969. Barron's Third would be Barron's Law Dictionary, 3rd edition, 1991. BDLT will be Barron's Dictionary of Legal Terms from 1983. Black's First will be Black's Law Dictionary, 1st edition, 1891. Black's Fourth will be Black's Law Dictionary, 4th edition, 1951. Black's Fifth will be Black's Law Dictionary, 5th edition, 1970. Black's Sixth will be Black's Law Dictionary, 6th edition, 1990. Black 7 will be Black's Law Dictionary, 7th edition, 1999. Bouvier's 6 will be Bouvier's Law Dictionary, 6th edition, 1856. Bouvier's 8th will be Bouvier's Law Dictionary, 8th edition, 3rd revision, 1914. F&W will be Funk and Wagnalls, Standard Dictionary, International Edition, 1958. OED will be the Oxford English Dictionary, 1971. UCC will be the Uniform Commercial Code, 1996. Webster's will be Webster's Encyclopedia Unabridged Dictionary, 1996. Words and Phrases, 90 volumes. WMP will be Words and Phrases, 90 volumes, 1968. WSUG will be Washington State Uniform Commercial Code User's Guide from 1999. Glossary. ab initio, Latin from the beginning, from the first act, blacks first. Absolute rights, as regards right to interfere with contractual obligations of another. Absolute rights which individual may exercise without reference to motive are rights incident to ownership of property, rights growing out of contractual relations, and right to enter or refuse to enter contractual relations. By the absolute rights of individuals is meant those which are in their primary and strictest sense, such as would belong to their persons merely in a state of nature, in which every man is entitled to enjoy, whether out of society or in it. The rights of personal security, of personal liberty, and private property do not depend upon the Constitution for their existence. They existed before the Constitution was made or the government was organized. These are what are termed the absolute rights of individuals, which belong to them independently of all government, and which all government which derive their power from the consent of the governed were instituted to protect. Compare droit. Acceptance, the voluntary act of receiving something or agreeing to certain terms. In contract law, acceptance is consent to the terms of an offer, creating a binding contract, the taking and receiving of anything in good part, and as if it were a tacit agreement to a preceding act, which might have been defeated or avoided if such acceptance had not been made. The act of a person to whom a thing is offered or tendered by another, whereby he receives the thing for the intention of retaining it. Such intention being evidenced by a sufficient act, black 6, an agreement either by express act or by implication from conduct to the terms of an offer so that a binding contract is formed. If an acceptance modifies the terms or adds new ones, it generally operates as a counteroffer, black 7th, a negotiable instrument, especially a bill of exchange that has been accepted for payment, black 7. Acceptance by silence, when the court implies a promise or holds that good faith requires a party not to violate these expectations, it is recognizing that sometimes silence says more than words, and it is understanding its duty to the spirit of the bargain is higher than its duty to the technicalities of the language. Corbin on contracts, see note. Acceptance for value, see note. Remedy, acceptance, value, holding due course, Baker's acceptance. Note, by acceptance for value is implied of taking an acceptance of something in exchange for another thing previously provided. Example given, a using credit balance previously established to purchase something. Value as peculiarly defined within the UCC is an esoteric term and implies that some sort of credit has been established beforehand, whereby the party with the credit may take, accept, purchase some item in commerce based on his credit. In other words, what is owed. It applies in numerous types of situations. Basically, if a party has established his position as a creditor of some sort, he can unilaterally accept, purchase, take anything that would help reconcile the credit discrepancy by executing that particular transaction. Such a creditor, having essentially a credit balance, need not obtain anyone's approval before so acting. One example of this is the acceptance for value of a document bearing the creditor's trade name. Example given, the birth certificate. The source of all credit and accountability value associated with the trade name is the sovereign flesh and blood man, woman, from whose true name the trade name was derived. Acceptance of a bill of exchange in mercantile law. The act by which the person on whom a bill of exchange is drawn, called the drawee, assents to the request of the drawer to pay it, or in other words, engages or makes himself liable to pay it when due. It may be by parole or in writing, and either general or special, absolute or unconditional, and it may be impliedly as well as expressly given. But the usual and regular mode of acceptance is by the drawee's writing across the face of the bill the word acceptance and subscribing his name, after which he is termed the acceptor. Blacks first, see banker's acceptance, bill of exchange, site draft. Parole, a word, speech, hence oral or verbal, expressed or evidenced by speech only, not expressed by writing. Blacks fourth. Acceptance of draft, certified check. A means the drawee's signed agreement to pay a draft as presented. It shall be written on the draft and may consist of the drawee's signature alone. Acceptance may be made at any time and becomes effective when notification pursuant to instructions is given or the accepted draft is delivered for the purpose of giving rights under acceptance to any person. B, a draft may be accepted although it has not been signed by the drawer is otherwise incomplete, is overdue, or has been dishonored. C, if a draft is payable at a fixed period after sight and the acceptor fails to date the acceptance, the holder may complete the acceptance by supplying a date in good faith. D, certified check means a check accepted by the bank on which it is drawn. Acceptance may be made as stated in subdivision A or by writing on the check which indicates that the check is certified. The drawee of a check has no obligation to certify the check, and refusal to certify is not dishonor of the check. UCC 3409. Acceptor. Acceptor means the drawee who has accepted a draft. UCC 31031. The person who accepts a bill of exchange, generally the drawee, or who engages to be primarily responsible for his payment. Blacks first. See note. Accommodation. An arrangement or engagement made as a favor to another, not upon a consideration received. Something done to oblige, usually spoken of a loan of money or commercial paper, also a friendly agreement or composition of differences. The word implies no consideration. While a party's intent may be to aid a maker of note by lending his credit, if he seeks to accomplish thereby legitimate objectives of his own and not simply to aid maker, the act is not for accommodation. Blacks 6. Number 1, a loan or other financial favor. Number 2, the act of signing an accommodation paper as surety from another. Blacks 7. See note. All your licenses, permits, utility services, bank accounts, travel documents, W-4 forms, tax returns, paychecks, etc. are in your straw man's fictitious trade name, not your true name. Until now, when you sign any of these items, you are signing for accommodation and obligating yourself, albeit unwittingly, on behalf of the trade name. See straw man. Accommodation endorser, a party who places his name to a note without consideration for purposes of benefiting or accommodating some other party. Blacks 6. See note, accommodation maker. Accommodation loan, a loan for which the lender receives no consideration in return. Blacks 7. See accommodation. Accommodation maker, one who puts his name to a note without any consideration with the intention of lending his credit to the accommodated party. Blacks 6. See note. When you sign a traffic citation, which is a promise to appear and then pay, in other words, a promissory note, you are the accommodation maker, your straw man, the accommodated party. Accommodation note, one to which accommodating party has put his name without consideration to accommodate some other party who is to issue it or is expected to pay it. Black 6 edition, UCC 3419, see note. All promises to pay are done by accommodation. The flesh and blood man or woman signs a note for accommodation on behalf of the trade name, the fictitious straw man trade name. An artificial person created by government is the transmitting utility. See transmitting utility, whereby all goods and services of the industrial society flow into and out of the possession of the flesh and blood man, woman. The straw man, having no life, no brain, and no body with which to apply a signature, must be accommodated by the actual attached man, woman, also known in this context as a surety. See surety. Accommodation party, one who signs commercial paper in any capacity for purpose of lending his name, in other words, credit, to another party to instrument. Such party is a surety. Black 6 edition, UCC 3419. See note, surety. Note, when you sign a traffic citation, IRS Form 1040, etc., you are the accommodation party. You are the source of all credit for the party whose name appears on the driver's license, social security card, etc., in your possession. You have provided the trade name with value, credit, your entire life. Accommodation surety. See voluntary surety under surety. Account, except as used in account for, means the right to payment of a monetary obligation, whether or not earned by performance. 1, for the property that has been or is to be sold, leased, licensed, assigned, or otherwise disposed of. 2, for services rendered or to be rendered. 3, for a policy of insurance issued or to be issued. 4, for a secondary obligation incurred or to be incurred. 5, for energy provided or to be provided. 6, for the use or hire of a vessel under a charter or other contract. 7, arising out of the use of a credit or charge card or for information contained on for use with the card. Or 8, as winnings in the lottery for other game of chance operated or sponsored by a state, governmental unit of a state, or person licensed or authorized to operate the game by a state or governmental unit of a state. This term includes healthcare services, This term includes healthcare insurance receivables. The term does not include 1. Rights to payment, evidenced by shadow paper or an instrument. 2. Commercial tort claims. 3. Deposit accounts. 4. Investment property. 5. Letter of credit rights or letters of credit. Or 6. Rights to payment for money or funds advanced or sold, other than rights arising out of the use of a credit or charge card or information contained on or for use with the card. UCC 9102 A2. See consumer transaction. Account number. See note. Note, same as account in the second sense. The sovereign creditor's mirror image private side of the governmental double entry bookkeeping ledger. Account number. Example given 1, 2, 3, 4, 5, 6, 7, 8, 9 of the strawman debtor's public side Social Security account number. Example given 123-45-6789. All IRS and state tax agency correspondence references the account number as the dash list version of the Social Security account number. Account debtor. Account debtor means a person obligated on an account, chattel paper, or general intangible. The term does not include persons obligated to pay a negotiable instrument, even if the instrument constitutes part of chattel paper. UCC 9102 A3. Accounting. Accounting, except as used in accounting for, means a record that is all of the following. A. Authenticated by a secure party. B. Indicating the aggregate unpaid secured obligations as of a date not more than 35 days earlier or 35 days later than the date of record. C. Identifying the components of the obligations in reasonable detail. UCC 9102 A4. Accusation, a formal charge against a person to the effect that he is guilty of a punishable offense laid before a court or magistrate having jurisdiction to inquire into the alleged crime. Blacks 6. Note, per listing of informant on the birth document and as subscribed thereby to one's mother, one has by definition had an accusation preferred against one. This is also very possibly the basis for all subsequent inconsistencies by Big Brother that the all capital letters name, trade name, references the man or woman so identified by the birth document. See informal. Identification of goods. Proper. All capital letters, written. Action. Action in the sense of a judicial proceeding includes recoupment, counterclaim, set-off, suit in equity, and any other proceeding in which rights are determined. UCC 12011, see set-off. Adhesion contract, a contract so heavily restrictive of one party while so non-restrictive of another that doubts arise as to its representation as a voluntary and uncoerced agreement implies a grave inequality of bargaining power. The concept often arises in the context of standard form printed contracts prepared by one party and submitted to the other on a take it or leave it basis. The law has recognized there is often no true equality in bargaining power in such contracts and has accommodated that reality in construing them. Barron's third, see note. Note, a driver's license application and an IRS Form 1040 are examples of an adhesion contract. Admiralty, a court which has a very extensive jurisdiction of maritime causes, civil and criminal. See note, Admiralty, maritime. See note, Admiralty law, maritime. Note, Admiralty courts, in other words, municipal court, superior court, etc., comprise the only jurisdiction that can enforce a criminal penalty for a civil offense. No other type of jurisdiction has this capability. This is why people must post bail prior to arraignment or trial and are sometimes sentenced to jail time, two aspects of criminal procedure for civil offenses such as traffic citations, wherein no party is injured and no property damaged. All courts in America operate as admiralty courts. Admiralty law. The terms admiralty and maritime are virtually synonymous. Blacks 6. Affiant, the person who makes and subscribes an affidavit. The word is used in this sense interchangeably with deponent, but the latter term should be reserved as a designation of one who makes a deposition. Blacks first. See note, affidavit. Note, as it relates to the redemption process, affiant is defined as the natural-born flesh and blood sentient being whose name is designated in upper and lowercase letters, one's true name in accordance with the rules of English grammar, who executes and signs an affidavit under oath. Affidavit, a written or printed declaration or statement of facts made voluntarily and confirmed by the oath or affirmation of the party making it, taken before an officer with authority to administer such oath. Blacks first. See note, commerce. Note, the capacity to issue one solemn declaration of truth, one sacred word, is the most basic, fundamental, underlying, foundational concept of all commerce, and sworn to before an authorized officer on the maker's commercial liability, that all assertions contained within the affidavit are true, correct, and complete, not misleading. The truth, the whole truth, and nothing but the truth. An affidavit is the most solemn, unequivocal, and ceremonial means extant to express truth without evasion, concealment, deception, or insincerity. As distinguished from testimony, an affidavit is not subject to cross-examination and is intended to be a complete, self-contained document. All truth is subjective, and only each free will being possesses the right, duty, privilege, and capacity to state that affiant's own truth in accordance with the unique nature, perspective, and priorities of the affiant. No one has the authority nor the ability to state the truth of another. As per the maxim of law, the order of things is confounded if everyone preserves not his jurisdiction. Because truth is supreme in commerce, an affidavit is the most important document in commerce and stands as the truth unless rebutted point for point by counter affidavit signed and certified on the executing party's commercial liability as true, correct, and complete. In other words, not misleading, the truth, the whole truth, and nothing but the truth. Exodus 20:16. The ninth commandment states, "Thou shalt not bear false witness against thy neighbor." The Bible is especially harsh on those who bear false witness. Lies are weapons that are easy to utter, difficult if not impossible to undo when spread as rumors, and can destroy lives. People often act on what is told to them and kill or are killed on the basis thereof, such as by marching off to war, believing authorities, or blindly obeying one's superiors. Caveat emptor is as wise an attitude in the field of words and ideas as it is concerning goods or services. For one group's official attempt at avoiding the consequences of bearing false witness, see Code Nidre. Affidavit of service. An affidavit intended to certify the service of a writ, notice, or other document. Blacks first. See note. Note, when using the mails, United States Postal Service for service of commercial process, it is always wise to include the original of an affidavit of service along with the item served. In so doing, one averts the potential claim by the recipient. I received the envelope, but it was empty. A sample affidavit of service is found in Part 2 under Handling Presentments. Agreement. Agreement means the bargain of the parties, in fact, as found in their language or by implication from other circumstances, including course of dealing or usage of trade or course of performance as provided in this code. Whether an agreement has legal consequences is determined by the provisions of this code, if applicable, otherwise by the law of contracts, sections 1103, UCC 12013, compared contract, see note. Note, in other words, you have formed an agreement in fact and are inextricably linked with the trade name by course of dealing, usage, trade, and of course performance. The legal consequences of the marriage with your straw man trade name is spelled out in the code where applicable. Where not applicable, it references section 1103, which states that all other forms of law shall supplement its provisions. The UCC is the supreme codified law on the planet. Legal consequences are dictated under the UCC. In law, and the UCC is the supreme law, there are only two kinds of people, debtors and creditors. All capital letters written, see note. Note, a proper name appearing in all capital letters falls outside the rules of English grammar, which authorizes the use of a capitalized letter only for a very limited number of well-defined uses, such as the initial letter of a proper name. A capital letter is defined as of letters of the large size used at the beginning of a sentence or as the first letter of a proper name. No lexical authority for use of all capital letters in the name of a man or woman has yet been referenced by those who would insist on corrupting the true names of men and women by displaying their names in all capital letters. An all capital letters written version of one's name is not one's true name, but an artificial construct existing by force of law only. No authority of English grammar recognizes such a contrivance. The legal term in propria persona means in one's own proper person. How can one do anything outside of one's own proper person unless there exists some other person by whom which one could act? Using the juristic artifice known as legal fiction, parties identified by their proper name have been ascribed corrupted all capital letter names. All legal proceedings, court records, and licenses use only names appearing in all capital letters. In other words, newborn artificial persons existed in contemplation of or by force of law alone. See legal fiction, proper, fictitious name, artificial person, item sonans, informer. Allodial, free, not holding of any lord or superior, owned without obligation of vassalage or fealty, the opposite of feudal. Blacks first. See note, allodium. Compare feudal. Allodium, land held absolutely in one's own right and not of any lord or superior. Land not subject to feudal duties or burdens. An estate held by absolute ownership without recognizing any superior to whom any duty is due on account thereof. Blacks first. See note at allodial. Appearance, coming into court as a party to a suit, whether as plaintiff or defendant. The formal proceeding by which a defendant submits himself to the jurisdiction of the court. Bouvier's eighth. Note, there are two kinds of appearance, general and special. See bail. Appellation, appealing, appeal. 1. The action of appealing to a higher court or authority against the decision of an inferior one. The appeal so made. B. Ground of appeal, title, claim. Number 2. The action of appealing or calling on, entreaty or earnest, address. Number 3. The action of calling by a name, nomenclature. Number 4. A designation, name or title given. A. To a particular person or thing. B. To a class. 1A. 1. A name or title. 2. The act of naming or calling. Act of calling by a name or designation. Webster's Collegiate Dictionary, 5th edition, 1947. Appealing, calling, naming. Appellation. See note section entitled The Calm Beneath the Calm and Maintaining Fiscal Integrity in Part 1 of this manual. Accost, to speak to first, address, greet, manner of act or addressing, greeting. Note, the significance of this term in your quest for personal sovereignty cannot be exaggerated. Appellation may be construed as simply a name, but its true meaning is infinitely more profound. Its actual meaning is that which is used by others for the purpose of gaining your attention. How you then respond after receiving such greeting, address, is the prerogative of a sovereign. Art, a principle put in practice and applied to some art, machine, manufacture, or composition of matter. Blacks first. Artificial, created by art or by law, existing only by force of or in contemplation of law. Blacks first. See note. Note, names of persons appearing in all capital letters are not written in English and exist only by force of or in contemplation of law. Persons so named are artificial persons. See juristic person, proper, all capital letters written, item sonans, fictitious name. Artificial person, see artificial person. Assignee, the person or business to whom a security interest in collateral is transferred. Attachment, the security interest attaches to collateral when it becomes enforceable against the debtor with respect to the collateral, unless an agreement expressly postpones the time of attachment. UCC 92038, see note. Note, depending on the type of collateral, a security interest attaches and becomes enforceable under different circumstances. See UCC 9203 for details. Under previous Article 9, which is still essentially in harmony with revised Article 9, when the three basic prerequisites of a security interest exist, in other words, agreement, value, and collateral, the security agreement became enforceable between the parties and was said to attach. Attorn, to turn to, assign, attribute, dispose, arrange, order, appoint, constitute, ordain, decree. To turn. The late AF became a turner, whence a turn passed into English law books. 1, to turn over to another, to assign, transfer goods, tenants, service, allegiance, etc. 2, to transfer oneself, in other words, one's homage and allegiance from one lord to another, to yield allegiance or do homage to as lord. 3, modified law, to agree formally to be the tenant of one into whose possession the estate has passed, to do some act which constitutes a legal acknowledgement of the new landlord. Attorney, to attorn, in sense of one appointed or one constituted, whence all the specific uses. The statement found in the law dictionaries for the last 200 years that the word means one who acts in turn of another is a bad guess for spelling. One appointed or ordained to act for another, an agent, deputy, commissioner, in later times only, figures, and perhaps with conscious reference to sense. Second, attorney in fact, private attorney, one duly appointed or constituted by letter of power of attorney to act for another in business and legal matters, either generally as in payment, receipt, and investment of money, in suing and being sued, etc., or in some specific act which the principal by reason of absence is unable to perform in person. Hence the contrast in person and by attorney frequent also. Third sense, a professional and properly qualified legal agent practicing in the courts of common law as a solicitor practiced in the courts of equity, one who conducted litigation in these courts, preparing the case for the barristers or counsel whose duty and privilege is to plead and argue in open court. 4, an advocate, pleader, mediator. 5, specific title of the law officer of various councils, etc., and the clerk of various courts. 6, the king's attorney. Descriptive designation of the legal officer now called Attorney General, Mr. Attorney, the style used in addressing formally also in speaking of him. 7, as an attorney, cunning, etc. See the truth about Esquires in part 1 of this manual, also attorney and client. Attorney and client, his first duty is to the courts and the public, not to the client. And whenever the duties to his client conflict with those he owes as an officer of the court in the administration of justice, the former must yield to the latter. The office of attorney is indispensable to the administration of justice and is intimate and peculiar in its relation to and vital to the well-being of the court. An attorney has a duty to aid the court in seeing that actions and proceedings in which he is engaged as counsel are conducted in a dignified and orderly manner, free from passion and personal animosities, and that all causes brought to an issue are tried and decided on their merits only. Duty not looked on lightly. Attorneys as officers of court have duty to maintain respect due court, which duty should exceed that imposed upon the public generally, and which duty should not be looked upon lightly and cannot be shirked under the guise of representing interests of a party litigant. Arm of state. As attorney is an officer of the court, and as such an officer and arm of the state. Nature and duty of obligation. One who is admitted to practice as attorney at law, both by virtue of his oath of office and customs and traditions of the legal profession, owes to the court the highest duty of infidelity. Accepting employment entails duty to the court. Accepting employment entails duty to courts and faithful performance of services, vital public interests. The relations of attorney and client is affected by vital public interests. Letters patent. Right to practice law is a property right, existing by virtue of letters patent. Corpus juris secundum. Practicing attorney. Ability which is greater than that possessed by average citizen. Corpus juris secundum 29, 1980. Accepting employment entails duty to courts and faithful performance of services. See note, by definition, the obligation and duties of attorneys are toward the court and the public. Abstraction of the mind that favors government, never the client. Clients are fodder for the freedom, usurpation, and wealth confiscation activities of the court. Attorneys are there to ensure that the court is well stocked with paying customers. It is a rigged game, with attorneys enjoying many special privileges, such as having their fees enforced by judicial decree, even when they lose, in exchange for shepherding unwitting client victims into court at the sacrificial judicial altar. Clients are also wards of the court and therefore persons of unsigned mind. See client, wards of court. Atonement. 1, a turning over, transference, assignment. 2, the transference of his homage and service by a tenant to a new feudal lord, hence legal acknowledgement of the new landlord. Authenticate. Authenticate means to do either of the following. A, to sign. B, to execute or otherwise adopt a symbol or encrypt a similarly process a record in whole or in part with the present intent of the authenticating person to identify the person and adopt or accept the record. UCC 9102 A7. Aver, in pleading, to declare or assert, to set out distinctly and formally, to allege, blacks first. Bail. By bail is understood sureties, given according to law, to ensure the appearance of a party in court, The persons who become surety are called bail. Sometimes the term is applied with a want of exactness to the security given by a defendant in order to obtain a stay of execution after judgment in civil cases. Bail is either civil or criminal. Bouvier 6. One who becomes a surety for the appearance of the defendant in court. Bouvier 8. To deliver the defendant to persons who, in the manner prescribed by law, become security for his appearance in court. Bouvier 8. Monetary amount for or condition of pretrial release from custody, normally set by a judge at the initial appearance. The purpose of bail is to ensure the appearance of the accused at subsequent proceedings. If the accused is unable to make bail or otherwise unable to be released on his or her own recognizance, he or she is detained in custody. The Eighth Amendment, U.S. Constitution provides that excessive bail shall not be required. Blacks 6. The surety or sureties who procure the release of a person under arrest by becoming responsible for his appearance at the time and place designated. Those persons who become sureties for the appearance of the defendant in court. Blacks 6. See note. Note, if a straw man trade name defendant cannot make bail, then the man, woman attached with the straw man trade name defendant becomes the bail. This is a formal legal recognition acknowledgement that this particular man, woman is a surety for the appearance of the dummy straw man trade name defendant, artificial person in court. See dummy, surety, appearance. And we're going to stop right here at the letter B. Bailee will be the next word we start at when we come back. I don't want to make this presentations too long. I do want to make them concise though. And I do want to thank you folks for joining me tonight on this presentation. Annotated Glossary. Like, share, and subscribe, people. Like, share, and subscribe. Do us all that favor. Like, share, and subscribe, and help with the analytics. Like, share, and subscribe, people. Like, share, and subscribe. And I will talk with you guys later.